New moves on Tuesday by that Randall S., the unhinged attorney, Newman Esquire, on behalf of Christopher, Denver Metro Audits Cordova, rattled the First Amendment anti-auditing community as the pair filed a motion for email service in Cordova's lawsuit against Frauditor Troll. Newman had previously filed an amended complaint on behalf of Cordova that alleged that Jonathan Frauditor Troll Who Know was not truthful in claiming ownership of his channel, as Google's records indicate that the channel is owned by Nika Ohiri. Tuesday's filing goes further, revealing that Ohiri registered the AdSense billing profile associated with Who Knows channels, was created on or about January 26, 2022, with the full profile being finished on or about August 23, 2022. Also included in the filing is the unredacted billing information leading to an Ontario address and full telephone number for Ohiri, which also lists frauditortroll@gmail.com as the contact email for the account. In the filing of multiple DMCA counterclaims, Jonathan Who Know claims full ownership and responsibility for the Frauditor Troll YouTube channel and listed a New York City address for service, along with frauditortroll@gmail.com email address. According to Newman's filing, Who Know himself has been silent on the lawsuit, providing no response to emailed waiver forms. However, after receiving the email, Who Know removed 1,700 videos from his YouTube channel, including most of the videos named in the lawsuit. A subsequent attempt to serve Who Know at the New York address that he provided failed, as Who Know failed to provide a suite number required for delivery of mail to the address. If it were an error by Who Know, he made the same mistake 12 times between July and October 2024, as each of his DMCA counterclaims filed by Who Know contained the same mailing address for service. Google's response to a subpoena filed by Newman on Cordova's behalf then showed that Who Know was apparently untruthful in his response to his DMCA counterclaim, as the AdSense account was owned by Ohiri, along with the Ontario mailing address. Who Know himself also mentioned in a recent face reveal that he and his wife reside in Canada, despite unconfirmed stories over the years told by the couple that they lived in New York and were just using a friend's Canadian address for mail service to protect themselves from doxing. Strangely, Newman's motion also suggests that service can be done through attorney Patrick J. Darcy, who previously made a failed attempt to file an amicus brief in the lawsuit on behalf of Who Know. Further, Darcy, whose email address is pat@patricklaw.net, admitted in his purported amicus submission that he had extensive discussions with defendants regarding this lawsuit. Service to these addresses is therefore reasonably calculated to provide actual notice. Defendants' awareness of this case is beyond dispute. Their refusal to accept service tracks directly with Darcy's threat to make this litigation very expensive and difficult. This demonstrates that defendants' evasion is not incidental but strategic, likely guided by Darcy's advice, and will continue absent court intervention. While Darcy's motion was rejected by the court, and Darcy has not issued a public statement since the ruling denying the motion, his actions leading up to the filing remain a concern for Newman and Cordova. Attorney Newman contended in the filing that Darcy's actions in filing the brief were more extreme than existing examples of case law allowing for email service. In his filing, Newman commented that Darcy made himself a party for service when he voluntarily interjected himself into the litigation and when admitted his extensive discussions with Huneau, despite Huneau not being a client. Newman went on to justify the request for email notification in a statement to ReallyCoolNews. This ex parte motion is about basic fairness. Defendants can't hide behind a fake New York address when Google's own records prove they've been monetizing from Canada the whole time. And thanks to Mr. Darcy's unsolicited filings, the court already knows they're fully aware of this lawsuit. The law is clear. Courts routinely authorize email service in Internet disputes. We are simply asking the court to hold defendants to the sworn promises they made in their DMCA counter notices. The motion by Newman is still pending before the court.